we're live somewhere. I'm not sure where, but there we
There
go.
we
All right,
are.
we are going live everywhere now on all our platforms,
Yes,
on
we are.
Facebook and Instagram. Good morning, everyone. It's 11 o'clock. It's time for Sand to Soul. I'm your host, Stuart Fournier, and I'm a 25-year veteran of the real estate world here in Los Angeles and specifically the South Bay. And it's my pleasure to introduce my lovely co-host.
Hello, everyone. It's Anastasia Bonholzer. I am a mortgage broker with AMS Mortgage Services, and I'm your go-to South Bay mortgage professional for Los Angeles and beyond.
And we apologize for not being on for about the last 3 weeks because we've had some real difficulties technically, but we're back. And the purpose of the show is to talk about real estate, not just about the market, but also inform you about things that you may not or may be misled about with regular advertising and, you know, some of the things you've seen on the TV news and what have you. And so that's why I wanted to pick a subject today. I kind of sprung this on Anastasia at the last minute. So she's just I know she's so talented, it's not going to be a problem for her. But anyway, the other day I was listening to a radio broadcast about basically a 1-800-TRUST, uh, application that you can get online and then fill it out and avoid all kinds of problems. And it just struck me as one of those things that I thought I'd share with the audience about how important trusts are and how that even though they are somewhat expensive and somewhat time consuming, are so necessary in the real estate process, especially, when you have the death of a loved one or someone's transferring property to you. It is a very complicated process. I think it's very misstated when people are going on the radio and TV and advertising that you can just download a form and fill it out and you're all safe. It's it's uh,
Yep.
it's really sort of alarming that they do that nowadays. So I want to talk about that a little bit and see what Anastasia's experiences with it, because I'm sure she's run into it as well. But before
Most
we get
certainly.
started, I just want to mention that if you have any questions or you'd like to participate, please feel free to leave a comment in the comment sections. We'll see it here right on the screen, and we'll be happy to answer whether you're seeing it live right now or whether you are seeing it recorded. Either way, we'll be happy to answer any questions for you. Uh, so, real quickly, I am not an attorney. I am not giving any kind of legal advice. Anything that I say today is simply as a matter of experience. And after 25 years, there's been a lot of experience, and this happens to be one of the subject matters that we've run into. So, with that said, one of the main reasons that you want to have a trust, especially when you own property, is because if anyone passes and there needs to be a reconciliation of what the value of the property is, the courts take over. And unless you have a trust, you're forced into something that's called probate. And probate can be very expensive. It can take years, and to and it's something that you do want to avoid if you can. A lot of
And
people think,
expensive.
pardon,
And expensive too. The
and
probate
very
attorney
expensive.
takes, from not from personal experience, but from what I witnessed, a probate attorney can take as much as 40 to 60% of the entire estate, which includes real estate and every other asset that individual who has passed on has left. And a will does not protect somebody from that action. That's the main thing.
Exactly.
Is a lot of people think a will, they're right on a napkin, my daughter gets the home, my son gets my 401k, and that's the end of that. No, it's a little bit more complicated than that. The probate will still go on even with the will.
Which is exactly why we suggest that you do hire an attorney. To be honest with you, what I have found is that trusts are anywhere from $3,000 to $4,000, which is kind of a high ticket item for people. I understand that.
Hmm.
But they're really necessary for the reasons that we've stated. But even more so, once you get them, you do want an attorney that's basically going to act as a custodian of your trust. In other words, your
Hmm.
circumstances in your life, your additions, in terms of family members' location. I mean, all these things matter. And so as life progresses and you own property and, you have major social changes or family changes, your trust has to follow those as well. That's my understanding. And so what you want is an attorney that not only writes one specifically for you, where you sit down with that attorney and actually go over your specific situation, where the trust is, written in a more direct way for you, not 1-800-TRUST. Uh, but also,
Hmm.
as life progresses, you want that attorney at least once a year reviewing your trust. Now, my attorney, for whatever reason, I'm not going to advertise for her, but she actually has that as all that's part of the package. Yearly, she's
Hmm.
going to
Hmm.
take a look at our situation, our family
I want to
situation.
chime in on the horror story that can happen if you don't update your trust. And it
Go
happened
for
to
it.
one of my clients who,
Yeah.
actually, I was working with the beneficiary. He had since remarried twice, and his original trust, living trust, was still tied to his ex-wife from 2 wives ago. And so then it became a very messy proposition because his real estate assets, based on what the trust was saying, was left to the first wife, not the second or the third. So,
Right.
anyway,
Right.
so it definitely updating it is highly recommended. Just because somebody does it once 20 years ago doesn't mean they shouldn't at least look at it to see what's in there.
Right. And another thing that happens very often, and this is super common that we've seen, especially when you get into escrow. When you get into escrow, your property is, gone through with a fine-tooth comb. And the escrow officers, of course, are the ones that, pay attention to all the legal aspects because obviously they are the ones who actually send your property to be recorded, and they have to dot their I's and cross their T's. And one of the things that we've noted over the years, and Anastasia, I know you can speak to this, is when you go get a loan, when you get an equity loan, or someone in your family gets a loan, or there's any kind of a lien like that type of loan against the property, and you haven't notified the loan company that it's happened, even if it's in the trust, guess what? You can tell them what happens.
Well,
Anastasia?
I'm not sure if yeah, it's, tell me again the question. I'm not
Okay,
understanding.
I'm
So
sorry. I
there's
was a
a
little,
there's
I
a
was a
lien.
little,
I don't understand the mechanics of the question. Yeah,
okay.
mechanics lien on the property, and the property is in a trust, you're saying?
Right. If
Or they put
you,
it in the trust after the recording of the lien.
so let's say you've done your trust and
Hmm.
you know, you're going to sell the house. But in the meantime, since you've done that, you've gone out and got a loan, but you didn't notify the loan company. Excuse me,
Hmm.
you did not notify the trust. I'm screwing this up. This has to do with the fact that if one loan company doesn't know that there's been another lien put on the property, they weren't excuse me, they weren't notified that that loan company cannot talk to the person who now is a member of the trust because that person has passed, for example. And so the loan company has an obligation to speak only to the owner of the property. And unless you've notified the loan company through a recording, this is my understanding, that that's happened, the loan company can't talk to you. They have to treat you as a third
Correct.
party.
Yes. Yeah, anytime there's a lien being placed on the property, a loan officer, or I'm sorry, a lender is going to place a lien either in the first or second position, and their only obligation is solely to the borrower, the person who dotted the I's, crossed the T's to that individual. Um, if another person comes in and claims to be the beneficiary, It just depends on how the trust is set up. So you're right. I mean, they're going to be
Right,
limited in information. Just a
right.
lot of it will depend.
And if there's no trust set up, then it becomes even more
And if
complicated.
there's no trust set up, that's when somebody would have to go to probate to address the issues of who actually will get the property at the end. And that's what
Correct.
the judge will then determine.
And in one of those situations, which we ran into years ago, we actually the successor, the person that was entitled to the property once one of the family members had passed, actually got letters in the mail that said, "Dear deceased." So the loan
Mm,
company is aware
right.
of the quagmire, and this usually happens during escrow. Your escrow company should put you in a position for that not to happen, to notify,
Hmm,
in kind
hmm.
of a transfer like that. We had it happen as
Sure.
well. When we transferred property, it turned out that one escrow company did the right thing, and in fact, we were successors to the property and that we received the property, but one of the equity loans had not done that. Now, I wanted to mention a vehicle that I found in the process that we experienced when this happened to us. And it's something that's called a Hegstad. Now, what a Hegstad
Hmm,
does is it kind of recognizes the fact that you've set up your trust, you've done all the right things. It's pretty clear that you're the beneficiary of the property. If you look at the trust itself, it's been spelled out in black and white. There's really no one else that has any rights. This usually happens when there's like one beneficiary and there aren't other family members and such. And so the court recognizes that in some instances, it's really unfair to send someone to probate when it's really not dotting an I or crossing a T, and that is notifying the loan company. And we ran into I've had have had it happen personally, and we had a client that was in the same position who, guess what, had used one of those 1-800 trust,
yeah.
and realized that during escrow it was going to take another 60 to 90 days in order to
Hmm,
work it all out. So we were able to
hmm, hmm.
contact a trust attorney that said, well, let's try what's called a Hegstad. And basically what that
Hmm,
is
hmm.
it's a application that you take before the judge and you say, look, the circumstances are pretty clear that there's no controversy here. It really was the escrow company or whoever was responsible for not dotting their I's and crossing their T's. And will you make an exception for this? And they, that, there's a possibility that they will. Uh,
Hmm.
Now, that again is expensive, especially if you're in a situation where you have a 30-day escrow and you have to close and you're not able to, so you'll lose the house. And you can't wait between 3 and 6 months to get a hearing date. So, um, the the more of a time crunch you have, obviously, the more of an emergency situation it becomes. So the attorneys have to therefore, do whatever they can to get into court and get before a judge in a reasonable amount of time. And guess what? That costs more money too. So the bottom line is
Hmm.
that trusts are very, very important, but even in and of by themselves, you have to maintain them. You have to keep them up to date. You have to make sure that all your you know I's are dotted and your T's are crossed. That's been my experience.
I agree. I agree. I mean, a lot of the times these days, my clients are like, why can I go to Chat GPT and Chat GPT can spit out an answer or a trust for me? And, we haven't yet seen the negative aspects of Chat GPT and how that affects the legal system. The laws are ever so changing, and Chat GPT doesn't yet have the capacity to go with the flow. Doesn't know the current tax codes, doesn't know what's going on geopolitically in the world, and does not have the ability, except for whatever you tell it, to understand what is legal, what is not legal, and what is current in the law. And a lot of the times, what if a law is overturned and ChatGPT has no idea? So don't rely on ChatGPT. Don't rely on a company, selling 1-800 trusts or whatever, the website is. And yeah, consult a professional. And we both have, professionals that we use for our clients and personally that we can refer you to in the South Bay who who we promise, who can take care of you. So,
Right. The bottom line here is that number one, you want to avoid probate. And number two, you want
Mhm.
to use an attorney, specifically an attorney that you're sitting down with. I guess you could say Zoom or meeting or whatever, but someone who does know you personally, someone who knows your situation, someone who's taken the
Yeah.
time to get you to fill out all the information about you so that they can write the most appropriate trust for you. So once again, one of the reasons we do this show is that we want to let people know about our experiences and the things that we've run into and the hassles and the circumstances by which you can prevent, especially
Hmm.
in the process of buying a property. Because as you know, when you make an offer and that offer is accepted, you're in a 30 to 60 to 90-day contractual obligation to straighten all these things out. And
Hmm.
believe me, they are not that easy to straighten out when you don't have your ducks in a row. And, again, one of the purposes of the show is to educate you about that. And Anastasia and I are happy
And
to
yeah.
sit down with you and, like she said, refer out. And yeah, we'll share our horror stories with you, you know, but please feel free to contact us anytime. So, anything else on the subject? Or are we going to cut it a little short today?
No, I think that's, yeah, I think I don't have anything further to say. I think
Okay.
that's, probate is important. It's important to update it. And it's important to have an actual human being review it because it's going to cost somebody more than 3 to 4 to $5,000 later on if there is no probate. I mean, if there is no trust, the probate process will cost significantly more than that.
Right, right. Okay, again, neither one of us are giving legal advice. We're simply, expressing some of the experiences that we've had and, some of the circumstances by which people get their heart broken. But, the bottom line is there's always a solution,
That's
there's
it.
always a way to
Over and
figure
out.
it out. And we're happy to, make any suggestions based on our experiences. So we'll see you next time on Sand to Soul. If you
Sounds
have
good.
a subject matter that you'd like us to talk about, or any questions that you have, again, leave them in the comments section. And again, we apologize for not being on the air for a while. Our thousands and thousands of fans were clamoring and calling. All right, now I sound like Donald Trump. But anyway, we'll see you next time. Take care,
All
everyone.
right. Sounds good.
Bye
See
bye.
ya.